Well, do excuse me, we still have a couple of minutes, so I would ask you for a bit of patience, kindly. I'm still waiting for one more very special guest. As soon as the guest is with us, we will be good to start, so I appreciate your patience. Thank you. Good evening, ladies and gentlemen. Thank you very much for joining us today. Warm welcome to the participants of this seminar, those in the room and those who joined us online. This seminar is a bit late because we're waiting for a very special guest who gave us the honor of the presence. Actually, everybody here is special in their own right, but I would like to honor one person in particular with big appreciation for all their efforts today. To date, the topic is the rule of law in Poland in the light of recent jurisprudence of international courts. That's part one. And part two will be dedicated to a presentation of a book I'm holding in my hand, Respect for the Rule of Law in Poland in the light of the case law of the Court of Justice of the EU. This meeting is organized by the European Commission representation in Poland. Warm welcome to the representatives, the National Chamber of Attorneys at Law in Poland, and the Law Department from the University of Social Sciences and Humanities in Warsaw. Well, this topic could not be more important, especially today in our country, today in Poland. It has generated so many problems for us lawyers, and it's really beyond imagination how many more problems could be generated looking ahead. This is one of the themes we would like to touch upon today in connection with the book, which is also, actually, the book is dedicated to Professor Adam Bodnar, who is with us today. Yes, as I said, this is dedicated to Mr. Bodnar. Today, December 10th, 2022, we wouldn't be having this meeting today if it were not for the International Day of Human Rights, which we're celebrating today. So the theme of our meeting could not be more relevant. Thank you very much. Ladies and gentlemen, without further ado, let me give acknowledgements, very, very quick, curt acknowledgements to all those in the room and those who have joined us online. I'm sure we have a big group of listeners and participants. I am the chair of Human Rights Board in our National Chamber of Attorneys at Law, and from, wearing that hat, I would like to give thanks to all our members. Let me just remind you very briefly that this voluminous book or paper is not the first one in a series. It's another one in a series. Professor Jan Barcz, Professor Agnieszka Grzelak, and Rafał Szydlauer, the editors, I wouldn't want to steal their show, because they will tell us in detail about the paper, the book, what we have in each volume, etc. We also have the pleasure of the company of the very authors of that distinguished publication. It hasn't been very environmentally friendly, I'm sorry to say. The rule of law calls for a very in-depth study. So we have lots and lots of pages, and we might actually meet next year as well. The door of our chamber, self-governing body of attorneys at law in Poland, is open wide to you, to us, whenever we need to discuss this topic. And I think without further ado, we should start the event. But before that, let me give the floor very briefly to the president of the chamber. We have the honor to welcome the ombudsman, Hanna Machińska, the ombudsman in Poland, madam. And on behalf of our self-governing body of attorneys at law, the National Chamber of Attorneys at Law, National Board of Attorneys at Law, on behalf of the president of the board, big thank you to you, madam, dear ombudsman, for your efforts to date and for all the efforts you are going to undertake looking ahead. We have a lot of respect for your work. Speaking on a personal note, I always admire all those who try to counteract all the things happening now in the administration of justice and in the judiciary in Poland. They are not fearful of the consequences, of the implications that they might suffer. And in that vein, Hanna Machińska, PhD, deserves our utmost appreciation and respect. So thank you very much, madam. We have every hope for collaboration in the future. We really count on you. You will help us prevent discrimination of some social groups. You will help us rectify the judiciary. Thank you very much. Well, dear all, first of all, I do apologize for being so late, but I had been convinced I would just sit down in the last row and participate in the meeting for a moment as a person who has every warm emotion towards all of you, and I'm so surprised in the best possible way with this recognition. It is indeed a special day, the International Day of Human Rights. It is quite symbolic, isn't it? I'm not sure whether you have seen the recognition ceremony for the Nobel Prize and the beautiful speech by Aleś Białacki. Adam Bodnar, who has always been supporting Aleś Białacki very closely. This has been quite sentimental when we seem to believe that, well, human rights should have been taken for granted in a very positive sense in Poland. Yet, as we have learned the hard way, there's a lot of room for improvement still. So just from me to you, I owe so much. I do owe so much to Adam Bodnar in my career and also to Professor Wyrzykowski. It was them who have made space for me, but first and foremost, Adam Bodnar. He made space for me to take action. And I will remember this time of my life as a time of agency. We really had a sense of agency in everything. It wasn't just a job, it was a mission, it was a vocation. And I am so pleased to have our friend with us. Mr. Mirosław Wróblewski has been a good spirit of our institution, still is. And let me just tell you this, I will not stop doing the good work. It's in our DNA. This is not going to stop. Of course, my work will take a different form, but today I would like to pay tribute to a big, big group of activists. It has been easy for me. It has been easy for me to be out there in the street, in the woods, on police stations, on precincts, because we had had this protective umbrella. We had the mandate of an ombudsman. We also enjoyed support from Adam Bodnar. He really made sure we felt protected. I'm speaking about the entire group of people. Today, we should focus our thoughts on those who have not had the support. They were counting on the ombudsman. They had to look to the ombudsman, and I hope they can continue to put their hopes in the institution of the ombudsman. I do hope that the situation will get better eventually, one way or the other. Anyway, thank you so much. I am taken by surprise and I feel very emotional. I'm very moved. To all my friends, big thank you. I'm delighted to see you, professors, Professor Barcz, and Mr. Ambassador Prawda, Professor Kranz, of course, Madam Professor Agnieszka Grzelak, so many distinguished personas. And I'm so delighted to meet you, Madam Professor. I have read so much of you, I've heard so much about you. So today it will be my pleasure to be here until 5 o'clock. I'm sorry, no longer, but then I have an NGO meeting. So thank you ever so much. Thank you, Madam Ombudsman, once again for your words, so relevant. And now let me give the floor to... Oh, yes, of course. I do apologize. but because of the traffic problem, we haven't had a chance to say hello yet. So yes, over to you, Madam Director of the university. Well, I do apologize for being late. The reason being roadworks in Warsaw. There's so much construction going on. I used to remember Powązkowska from time immemorial, but today it looks so different. So the GPS misled me, and because of that, I found myself in Powązkowska 95 Street instead of 15. Of course, it's no excuse. Please accept my sincere apology. It's a lesson for me to always leave earlier. So first of all, thank you very much for this meeting. Thank you for joining us, for inviting us. As the EC representation in Poland, we can now participate in this important event. In December, it's hard not to remember December 2015. It was then, for the first time, that I was in the European Commission. I was wearing a hat of an officer there. So when this big dispute over the Constitutional Court started, it was December 2015. And I really need to share it with you that ever since 2015, in fact, in spite of so much effort on the part of the European Commission, not only cannot we enjoy de-escalation of the dispute, no, even worse, we have seen aggravation, huge aggravation of the dispute on the rule of law and disrespect for the rule of law. It's a dispute between or with the European Commission, but also with the European Union Court of Justice. So in fact, ever since the Law and Order came to power in the fall of 2015, we have seen continued aggravation and, more and more problems related to the violations and lack of independence and autonomy of Polish judiciary. At that time, as the EC representation in Poland, we have been quite active in spearheading the effort. Well, we're not a political party, so it is not our mandate at all to intervene too deep, because it's a matter of a democratic elected government and the sovereign state. But speaking about the rule of law, which is the absolute foundation of the EU, from day one, not only do we inform the public opinion, but Ambassador Marek Prawda in particular, he was the head of the representation between 2016 and 2021. He really was instrumental, in being a liaison and an independent broker who tried to explain what's happening in Poland to the Commission and also to explain to the Polish authorities what the position of the European Commission was. The then Deputy President of the EC, Franz Timmermans, and Bers Mulders, his head of the cabinet, they have been really trying to make sure that we would avoid the escalation. And this initial dispute over the Constitutional Court, they really wanted to patch things up. They were even writing ready-made scenarios, step by step, on how to reach the compromise. And that was feasible, more than feasible. It was very well possible. We also had Ambassador Marek Prawda, and with all his authority, power, and position, he really put everything at stake. But on top of that, we also had a colleague, a lawyer, who is with us today. Rafał Schindlauer is his name. So Mr. Schindlauer is a public official in the EC, but he's also a lawyer. So thanks to his legal background, he took over the burden of analytical and translation work, those very, very new, very fresh text of the law he translated into English. So the European Commission representation has always been really committed and involved, and many people had a grudge because of that, but we see that as our mission. Then last year, Filip Skawiński, PhD, took over the baton from Rafał. He's a lawyer as well. And following in Rafał's footsteps, he has been organizing a lot of training sessions, training events which are targeted at judges. They are designed for judges. Their purpose is to teach Polish judges about the judgments and the case law of the Court of Justice. We always invite judges, we always invite Ministry of Justice officials, so nothing is kept under the lid here. So the fruit of all that work of the last few months is the third volume. Actually, it says volume 2, but it's the third volume consecutive, right? I have not seen it before, because I know that towards the end, well, the work was really, you were very, very busy to get this published on time. So it's the third volume in the series.
The third volume, which is significant because all of those who in future will want to find out or find their way in this very complex dispute over the rule of law will be able to find the relevant documents here. And I also hope that agreement will be reached, as Dr. Machińska said, not only the agreement with the Commission, but that the issue of the future and independence and the rule of law in Poland is something that will eventually be resolved, and I won't have to sign another contract for publishing another volume of this. This volume is dedicated to Professor Adam Bodnar, and I wanted to thank both you, Professor Bodnar, and you, Ms. Machińska, that you are the Lichtblicke of Polish rule of law, that you make sure and really care for, and thanks to you, still, it's not that our entire country is perceived as a country where the rule of law is really backsliding rapidly. Unfortunately, in recent months, the disrespect for the rule of law has been shadowed with the issue of the payment from under the National Recovery Plan. And this is bad, because what we are worried about is that the public opinion will draw the conclusion that we shouldn't really deal with the rule of law because we've got here 100 billion zloty waiting for us, and we really should compromise just to get this money in order to just save these payments. I do hope that the Polish public still has this awareness that independence of the courts, of the judiciary, is absolutely fundamental for the economy, for the politics, for the functioning of the society. Thank you very much, and I wish you all an interesting evening. As you can see, the conference is live, which can easily be seen with all the changes. So let me thank you, Director, for this speech, and the European Commission and the people you have already mentioned. And now I'd like to invite Professor Adam Bodnar, the Dean of the Department of Faculty of Law at the University of Social Sciences and Humanities, former Ombudsman. Ladies and gentlemen, first of all, let me thank you for this possibility to work together on this event today. And I want to give a smile to Hanna and thank you for all those nice words that I've heard here from you. But my role here at the beginning is to introduce and say a few words about our special guest, Professor Angelika Nussberger. Professor Nussberger will give us a lecture from Kudeszkina to Juszczyszyn, rule of law in the jurisprudence of the European Court of Human Rights. Who would think that Polish cases involving Poland would contribute so much to the development of the jurisprudence of the Strasbourg Court? But let me say a few words about Professor Nussberger. when I was thinking about what to say, I decided that I would like to present all the achievements and merits and membership in different committees. If I wanted to list all of those, it would take me probably at least 30 minutes. So let me just mention the most important things. Professor Nussberger has been attached to the University of Köln, where she now runs the Academy of European Human Rights Law, which was founded on the basis of a former institute dealing with human rights and the institute dealing with studies of Eastern Europe. It's also worth adding that professor specializes not only in law but also in Slavic studies, and she has also carried out research on legal systems in the countries of Central and Eastern Europe. And I do assure you that if you are in this institute, you can find books there about the constitution and constitutional system of Turkmenistan, Kazakhstan. Really, I don't think there is any other place in Europe where all this information can be found in such a detail. Professor Nussberger is a former court of the European Court of Human Rights. She was the deputy president of that court. And I think what is important for us is that among other cases that she ruled on was the case on the Katyn crime, Janowicz versus Poland. Right now she works in the court for Bosnia and Herzegovina, which groups judges from other countries than Bosnia and Herzegovina. So Professor Nussberger from time to time just goes there and resolves cases in Sarajevo. She's also the member of the Venice Commission, and I don't think we need to explain what Venice Commission is in Poland and why it is important from the point of view of shaping international standards. Let me also add that she works very closely with organization of OSCE, and she's recently prepared a fundamental report about the condition of civil society and all the changes related to civil society in the Russian Federation as part of the Moscow mechanism of the OSCE, which allows to prepare these types of reports. Professor is also It's also been awarded a number of awards. She holds 2 doctorates honoris causa from University in Sibiu in Romania and Tbilisi in Georgia. She's also a member of various scientific boards, academic boards. She's also the member of the editorial committee of the one of the Polish magazines edited in Poland on human rights. Professor, over to you. The floor is yours. Bardzo dziękuję. Szanowni koledzy, niestety nieczęsto bywam w Polsce, w Warszawie, ale zawsze kiedy tu jestem, czuję się bardzo ciepło przyjmowana i chcę Państwu za to bardzo.
And I just want first to turn to Mrs. Machinska, because when I arrived on Thursday, it was almost one of the first news I heard about you. And I met my friend, Professor Wyszykowski. Where is he now? Ah, there he is. And he said that he had attended a demonstration in favor of you. And I asked what has happened. And so my stay here in Poland these few days is full of your name. And I was so happy to meet you and to see you smile and to see that you see a future for your human rights works. And I think that is extremely important. And with that, please allow me to say hello to my really dearest friends here. And I want to start with Anna Wierusomska. I didn't expect her here, but actually she was, I think, the first one where we concluded a contract, but with or without a contract, we had a very intense working together. It started probably in the early 2000s, and I was so happy to meet her here. And then my 2 good friends, Mirek Wyszykowski and Adam Bodnar, who are my permanent dialogue partners, and Adam is now a visiting professor at Cologne University, and I can tell you my institute with all those books about Turkmenistan, they prefer human beings to books, and when Professor Bodnar comes, they are all very happy. And also with Professor Wojciechowski, we meet in Heidelberg, we meet in Athens, we meet everywhere to discuss, among other things, about the rule of law in Poland. So thank you so much for your invitation to be here today, and sorry for not speaking your beautiful language, but I never managed to really learn it. So, the question of today, rule of law in Poland, I was reflecting what I could say about rule of law when I come to you. I mean, you know all so much better from inside. My point of view is more the analytical point from the Strasbourg perspective. And so the question I want to ask is the following. There is an everyone's right to be judged by an independent court. It's enshrined in Article 6 of the Convention. But is there also a judge's right to be independent? So this is the way I want to turn it around and to have an analytical approach to the jurisprudence, because what I can tell you, it's a very complex and difficult jurisprudence, and it had to be developed on an almost day-to-day basis, with the countries in Europe moving in one direction and the court having to adjudicate cases with really new problems for the court. So to this answer, if a judge has a right to be independent, it's very easy. You can have two answers. The one is no, and the other one is yes. So these two answers were interestingly discussed in one of the first big cases on this topic, and that was Baca versus Hungary in 2016. And in this case, my two colleagues, I was just in the majority, writing nothing special in this judgment, but my two colleagues, on the one hand, Alexandra Sicilianos, the judge from Greece, and on the other hand, your colleague, Krzysztof Wojciech from Poland, they wrote separate opinions in this case. And they laid out the different visions of this idea of the right of a judge to be independent. So I want first to explain their different points of view on this topic. And then my thesis, my personal thesis, is that a subjective right of a judge to be independent is in statu nascendi. So it's something that's about to be elaborated, but we are not absolutely there. We are on the road, I would say, we are on the track. And it's very difficult because it's a right that you cannot center on one article of the convention. It's a right in between several articles. And as you see also in the Polish cases, you use different articles for these cases of independence. And so we have to admit that it's something where we have to think up a lot about also the role of the convention and the possibilities to develop it further, because a right of a judge to be independent means basically that a special professional group, judges, have specific human rights. And that is not something that follows smoothly out of the general convention philosophy. So let me start with the different lines of case law and then come to these separate opinions. So the starting point, we all agree, is Article 6 of the Convention. In the determination of his civil rights and obligations or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial court established by law. We all know that. So it's clearly the right of everyone, not the right of a judge. It's the right of everyone, and the independence of the judge is something the persons are guaranteed to have, not the other way round, not something the judge is given. So the traditional approach is based on the classical formula, I'm going to quote, in determining whether a body can be considered to be independent, notably of the executive and of the parties to the case, the court has to regard to the manner of appointment of its members and the duration of their term of office, the existence of guarantees against outside pressure, and the question whether the body presents an appearance of independence. So, manner of appointment, duration of the term of office, and guarantees against outside pressure, that all concerns the judge, the position of the judge, but it's seen from outside, not from the perspective of the judge. And that becomes very clear when you look at this appearance of independence, because appearance is something you see from outside. It's not about the feelings of the judge, if he or she feels independent, but it's for us if we think that judges are independent. So basically, it's the perspective on the judge and not the perspective of the judge. So we have, in our jurisprudence, we have identified two sorts of lack of independence. One is a specific situation where judges are not independent. So, like pressure on the judge, and the most famous case is probably Sovtrans Avto versus Ukraine, where the president of the country sent a letter to the judge and said, you have to decide like that. A better form of pressure is probably not possible. But we know pressure can come from the executive, but also from the legislative, but also from the judiciary. From inside, there can be pressure as well. So this is a specific situation of pressure. But we also have the general structural problems, and that's now this Gudmundur Andri Astrason case law, where it's not a specific situation, but a general structural problem, like the position of a disciplinary chamber in a legal system, or unlawful appointment of a judge who judges and continues to judge, so this is a systemic problem. But in all those cases, it's from Sovtrans Avto to Gudmundur Andri Astrason, it's always about civil rights and obligations of applicants. They bring their cases, criminal cases, civil cases, to the court, and then we have to decide about the independence of the court. And now we have the new case law, line of case law. That's where the judges themselves complain. Not the applicants, but the judges. And that starts basically with Kudieshkina. There might be other cases before, but Kudieshkina was a big case. We have Volkov, we have Ramos Nunes versus Portugal, we have Denisov versus Ukraine, we have Baka versus Hungary, and we have a lot of Polish cases. And they do not necessarily complain under Article 6. They can complain under Article 8, under Article 10, under other articles. And in the Baka case, it was raised for the first time on this theoretical level to say, what is now the position of the judge, him or herself? And here we have, as I said, the concurring opinion of Alexandre Sicilianos and the dissenting opinion of Krzysztof Wojtyczek. So let's look at the two arguments about this question if a judge has a right to be independent. So you know Baka was the president of the Hungarian Constitutional Supreme Court, and with the change of the constitution, he lost his job as a president. So Alexandre Sicilianov, he said, yes, there is a right of a judge to be independent, and he referred to a lot of soft law standards, like the Magna Carta of judges, and like Venice Commission opinion, but it was really the quotations he found were always very vague. It was not explicitly stated. He also found something in the jurisprudence of the Human Rights Committee and the other UN bodies, but it was very vague, something, I quote his quote from the Venice Commission: "The interest of maintaining the independence of the judiciary and the good administration of justice requires that the judiciary be protected." But that is not yet, that we would say clearly, a subjective right of a judge. So he took this soft law for his thesis, but it was a bit shaky. But he also quoted the Inter-American Court of Human Rights. He saw it as a perspective to develop. Now, the arguments against, and that's Judge Wojciech. Judge Wojciech said we have to distinguish between individual rights pertaining to the private sphere of the individual and official tasks. So private individual and official tasks, and human rights protections, that's his argument, is for the private sphere but not for the official tasks of a person. That's something different. So I quote Krzysztof Wojciech. He says, "The guarantees of judicial independence are not special human rights granted to individual persons holding judicial office, and they do not increase the degree of protection that individuals holding judicial office enjoy as human rights holders. Equally, they do not broaden the scope of the human rights enjoyed by those individuals. On the contrary, judicial integrity and independence may justify deeper interference with judges' rights than in the case of ordinary citizens." So just the other way round. So he explains that judges are in the service of the community, and they are vested with public power, and that's why they are not having this right to judicial independence. Let me quote him once more. So he says, "Judicial independence and irremovability are not laid down to protect the individual interests of judges or to facilitate their personal self-fulfillment, but rather to protect the public interest in fair judicial proceedings and the proper functioning of the justice system. They protect those citizens who seek justice, but not the individuals who exercise judicial powers." So the consequence of Judge Wojciech's approach is that the European Court of Human Rights cannot play a role in rule of law cases because basically it does not apply. And he says, I quote him now for the last time, no, perhaps not for the last time, but for the time being, "The instant case, so the Baka case, is a public law dispute between two organs of the Hungarian state, the Supreme Court and Parliament, acting in its capacity as a constituent power." And then he says it's outside the scope of the jurisdiction of the European Court of Human Rights. And then he continues, "Other tools exist for protecting judicial independence within the framework of the Council of Europe and within the European Union." But he does not tell us which other tools. This is the open question. Which other tools do we have? Now, so you see the yes answer and the no answer. And now let's look at the jurisprudence and let's look at the difficulties the court has to develop such a right, along with political events happening all the time. So first, we have to admit that in the letter of the convention, there is no such thing as a judicial independence, right of judicial independence to the judges. We have values like the reputation of the judiciary, so you can restrict, for example, freedom of expression in order to safeguard the reputation of the judiciary. And you also have the right of others, so when you have the secret of deliberations, the rights of others are protected, so judges cannot talk about the secret of deliberations. So literally, the interpretation is not the most obvious one. And if we go along with a traditional, I would call it, teleological interpretation, and we ask about what the convention is, we would say, well, judges are basically, in the separation of power system, they are exerting state power. And as human rights protection is between individual and state, judges are on the other side. They are not on the side of the individuals, but they are on the other side. They are state organs, and it's expected from them to be loyal to the state. So these are our problems in developing the case law. Now we have different cases. So cases, it's never like an architect making a plan, but cases come one by one, and judges have to develop the case law one by one. And so we have Article 6, and some of the cases are under Article 6, access to court. And just in a recent article, Mathieu Leloup and David Cossard, they argued that access to court is one of the main angles to tackle these cases. And there we have the Baka case. So the Baka case was about access to court, or also the Polish Książta case was about access to court. And then you have to define the right of the judge in, well, there it was in the constitution or somewhere, to have a certain mandate, or you have to have a right, and this right has to be qualified as a civil right. And all that is not easy, because the jurisprudence of the court refers to the exercise of state power and special bond of trust and loyalty to say it's no civil right. So you have to jump over this difficulty to argue that it is a civil right, and you do have, judges do have access to court. But that's what the court has done in all those judgments like Baka and Książta. So that's the first right that is applied. Another right is right to fair trial, but that's very specific, because it only applies when the trial against the judge suffers from fair trial problems. And there also we see problems like I was sitting in the Volkov case, which was quite clear. We didn't accept the Supreme Administrative Court as an independent court, because it was under the disciplinary procedure of the body which had issued the order the administrative court was judging. So we said, this is not an independent court. But then, and I was also sitting in this case, in the Portuguese case, Ramos Nunes, we had actually a very similar situation. Also the court, the Supreme Administrative Court, and a disciplinary body, and the order of the disciplinary body. And there we said, but we cannot transfer what we have found in the situation of Ukraine to the situation of Portugal, because of the different legal culture. And I read out this very difficult part of our judgment. We wrote, these findings should be regarded as a criticism, so the findings in the Volkov case should be regarded as a criticism based on the circumstances of the case and applicable in a system with serious structural deficiencies or an appearance of bias within the disciplinary body for the judiciary, as was the case in the specific context of the Ukrainian system at that time, rather than a general conclusion. A purely abstract risk of this kind cannot be regarded as apt to cast doubts on the impartiality of a judge in the absence of specific circumstances pertaining to his or her individual situation. So what is good for Ukraine is not good for Portugal. That's a problem. 17 judges, 6 out of 17 judges dissented in the case, and they argued, I quote, "We believe that the principle set out in Volkov is fully applicable in the present case." Just to tell you the problems we had to cope with in order to develop an adequate jurisprudence. What is legal culture? Does it count? Can I transfer everything from one system to the other? So you see, Article 6, it's not easy. Article 10, we have a lot of Article 10 jurisprudence about independence of the judges, but there as well we are faced with problems. So the first case was Kudyeshkina, where she spoke out against the Russian judicial system in very, very harsh terms. So what she wrote was quoted everywhere to say Russian courts are never independent. And it was the question if a judge is allowed to speak out so critically against their own judicial system, because of course it undermines the reputation, and we have that as a restriction to Article 10. So the dissenting opinion of Judge Kovler and Judge Steiner, they wrote about the judicial ethics of a court, and they said, I quote, "Judges shall exercise their freedom of expression in a manner compatible with the dignity of their office. They shall refrain from public statements or remarks that may undermine the authority of the court or give rise to reasonable doubt as to their impartiality." So, not so easy. Should we restrict judges' rights to criticize their own legal system? Nevertheless, this was the basis for adjudicating the Bakker case, the Kudieshkina case, and other cases. But it was seen to be necessary to have a judiciary-specific use of freedom of expression, like criticism of the judicial system. It was necessary to have a specific authority in the field. It was necessary to have a relevant topic for society. And in Kudieshkina, it was also the argument that the inside perspective is invaluable because nobody from outside would know what the pressure on Russian judges is. And in such an important issue, it's necessary to listen to them. And for Bakker, it was the criticism of the judicial reform. But here as well, you see judges were divided. We had in Kudieshkina a 4-3 judgment, so it was quite close. And to quote once more Judge Wojtyciak, who doubts here as well in the value of this jurisprudence. So he says, I quote, "In other words, judges' official speech is not a matter of individual freedom, but remains very strictly circumscribed and subordinated to the promotion of specific public interests. Public office in the judiciary is not a rostrum for the exercise of free speech." So here again, he is very critical of using Article 10. Okay, it's not the last option we have, Article 6, Article 10, we have Article 8, which is used quite often. But there as well, if you look closely, it's not easy, because expressis verbis, it protects private life. And that's not professional life. It's meant to be private and not professional. And the court is not meant to be the superior judge in all employment disputes. That's not the idea of the convention. So Judge Wojtyciak wrote in Bakker, "There is no human right to preserve public power in this context." So in this context, we are always confronted with dismissals, suspensions of judicial office, or removal to another post, all that. And the question is always, does it also touch upon private life, not only professional life? But there our argumentation is sort of going around, because the real issue is professional life. And we have somehow to argue to anchor it in private life, although we know better that it's basically about professional life. So, what else have we left? Article 1, Protocol 1, not very helpful. It was usually pushed aside. In Bakker, it was said there is no right under the convention to continue to be paid a salary of a particular amount. That was repeated in other judgments, so property does not help us either. And in Juszczyszyn, very difficult Polish name, Juszczyszyn, Juszczyszyn, I try my best. We had Article 18 applied, but Article 18 is not sort of a solution for all the problems, because it has always be linked to another article in the convention. So I have already to find a hole where I dive into the case. And then this ulterior purpose, it's also difficult. What is the first purpose of the dismissal, for example, and what is the ulterior purpose? If I say that there is a disciplinary measure against somebody because he or she has acted against judicial reform, it's probably not an ulterior purpose, but it's the direct purpose. So it's also not always obvious. It always depends on what you see as the right judicial reform and then you can, from there on, you can define what is an ulterior purpose, but it's also, it creates problems. And just now I have seen in the case of the judges who were removed from the criminal court to social chamber just very recently, where we had an interim decision, that they argued on the basis of forced labor. I don't know what's going to come out of that, but that's also one probably new approach. I don't know what the court will do with that. So what I want to tell you, it's not easy. It's not easy for a court because all what we have fits a little bit, but does not really fit so very well. So what should we do? We should see also the very spirit behind the convention. And we should see that there are no human rights without independent judges. So it's the basis for all and everything. And that's why I think we have a legitimacy to be quite going far in our interpretation, because that is a red thread running through the whole convention. And let me just quote Pierre-Henri Taillejean, who was one of the authors of the convention, who said, right is preeminent over might. So we have this rule of law basis, and this basis of having rights is central to the whole convention. And in this regard, we find now in the Kirchner case, for example, I would say a credo of the court that is willing to go into this direction of having a right of a judge to be independent, where it says the court reiterates that judges can uphold the rule of law and give effect to the convention only if domestic law does not deprive them of the guarantees required under the convention with respect to matters directly touching upon their individual independence and impartiality. So the court links up the objective rule of law and the subjective rule of law factor. So, last words, conclusion, status quo of the jurisprudence. Once more a quote of my colleague Krzysztof Wojtyczek. In the Kirchner case, he wrote, "The approach adopted by the majority in the instant case sets aside those fundamental legal concepts and distinctions and substantially transforms the paradigm of human rights protection in Europe." We have indeed a new human right of a specific group of persons, of judges, human rights, specific rights of judges, a subjective rights of those having a specific function for the state. I think Judge Wojtyczek is right. It's indeed a new paradigm that we are developing here. I would argue it's very much in the spirit of the convention. And the problem is it's not perfect. We see that it's always a bit shaky. It's always, you can always find counter arguments. And you also have to ask, what about a judge who does not stand up, who is not loud, but still is oppressed? It should already be a violation of human rights. The oppression as such, even if he or she is not dismissed, if he or she is not suspended, already that should be a human rights violation, which I cannot catch, actually, with jurisprudence that we have. But I think it's also linked to a new vision of judges. Judges are, in this vision of this new jurisprudence, they are no longer part of the state only, but they have a sort of hybrid function between the state and civil society. And I think that's quite a realistic situation of view of the situation. Now my last quote of Krzysztof Wojtyczek, he says, "The convention protects individual rights. Objective guarantees of the rule of law may have a more or less direct impact on the status of the individual, but are primarily enacted to save the public interest." I think that's correct, but I also think it's only half of the truth. Because the convention protects human rights not only for individuals, but also in order to safeguard the state from sliding back into authoritarianism. It's not only, human rights are not only there for protecting the individuals, but also society as a whole. And there I want to quote one of the most famous quotes of Henri Taïdjan, as I said, the author, one of the authors of the convention, where he talks about the conscience of Europe, and that's then the symbol for the European Court. And I just let me give you this quote. He says, "Evil progresses cunningly with a minority operating, as it were, to remove the levers of control. One by one, freedoms are suppressed in one sphere after another. Public opinion and the entire national conscience, there it is, are asphyxiated. It is necessary to intervene before it is too late. A conscience must exist somewhere which will sound the alarm to the minds of a nation menaced by this progressive corruption, to warn them of the peril and to show them that they are progressing down along a road which leads far." End of quotation. So that's the whole idea of the convention, this alarm bell. And this alarm bell has to shrill. It has to make a lot of noise, and we have to react. And it seems to me that this conscience can be attached or seen, incorporated in the judges who feel oppressed and stand up against this oppression. And it's them who ring the alarm bell, and we have to react if we want to uphold the values of the convention. Thank you very much.
Okay. Okay.
Ladies and gentlemen, let me thank Professor Mosenberg very much for fantastic and very inspiring lecture and a view on those issues from a completely different perspective than we here have in Poland. This is a seminar, and we will then have a panel discussion, but right now the organizers let me know that we have about 20 minutes for questions, for discussion, for responses to what we've just heard from Professor Nussberger. And we have various options in which the questions can be asked. We can ask questions here in the room. We know that some people are also connected with us, Professor Biernat, for instance. And as far as I know, we can also get questions from the chat, from people who have been watching us online. So I do encourage you to post your questions, but of course, first of all, we will hear questions from people sitting here, then Professor Biernat, because I would really like Professor to comment and to respond to what we've had from Professor Nussberger, but I will also be collecting questions from the internet, from people who wanted to come here and not just to see the football game. So, who would like to ask a question? Or maybe make a comment in the discussion? Okay, Professor Wyrzykowski. Thank you very much. Thank you very much for this very interesting lecture, very interesting analysis, and very interesting perspective that has been shown to us by this way of understanding how to get to a conclusion that for us, people here in this room, have been obvious 5 or 6 years ago. But both the European Commission and the European Court of Justice and the European Court of Human Rights in Strasbourg had time to understand that analysis of just a single provision that seems to be in violation of the convention or the constitution is just not sufficient in order to understand what the role this particular provision plays in the entire legal system. So it had a lot of time had to pass for European lawyers to understand that the world in which they had been operating, those legal reasoning criteria that they treated as a standard, was not really the world in which the law in Poland has been created after 2015, particularly the law related to the mechanisms of human rights and the operation of the state. But we have got there, and I think that this is absolutely the best example showing that the political machinery to destroying the constitutional state, first of all, division of power, independence of the judiciary, and the civil rights and freedoms can actually be stopped by the judiciary. It started from the case in Luxembourg and from Baka that we've heard, and also Polish complaints filed with the court in Strasbourg. So the power of law and not the law of might, right, changes also the way in which political authorities operate, even those who disregard the Constitution and the European law. And my question is about the case that you've mentioned. 3 female judges from the appellate court in Warsaw who were removed against their will to work in the social and labor law cases court. And in the last paragraph of the judgment on interim measures, the court states that
decision to transfer the applicants from criminal division to the labor division. How, w jaki sposób?
How should we understand the word suspend? How? What does it mean? Because then we hear about the prohibition for the future to undertake, for the court to undertake, and I understand that applies also to other courts, a prohibition to transfer judges without their consent to other courts. But how should we understand here the term suspend?
Yeah, thank you for the comment first and then for the question. Yes, this interim measure is something really new. So I'm out of the court for 3 years now. And when I was there, it was absolutely the only possibility to apply interim measures was for dangers of life and limb. So all the others, and I was what we call duty judge, so the one deciding on this interim measures for 3 years, and you get calls all the time wherever you are, and it was always to decide danger for life and limb. And that is obviously not the case in this case, and that's a problem because the court has then developed its jurisprudence on interim measures, and it's fine to develop the jurisprudence, but it's a problem to do it with interim measures because interim measures are not argued. And you have, as you have seen, you have the press release, but you don't have the real arguments and you don't have an exchange of arguments. And to go ahead with a new development of jurisprudence should be done in an argued way. So how could we at all develop interim measures? So what is behind this development is the idea that not only questions of death and life and dangers for life and limb are sometimes lead to irreparable harm, but also undermining rule of law in a specific system. So this is the philosophy behind, but the court cannot state it because interim measures are not judgments, but just press releases. So this is the problem. And you ask me now how to interpret it. So it's a general question how to interpret press releases, because it's not the authentic part. It's the only thing that the court communicates, and we know it's binding under international law. It's binding. So to suspend means not to do what they have done. So they have already been moved, as I understood. So this measure should not have legal value until the court has decided the case. So this is the idea. I'm afraid that the court might be very much criticized for this move, because the irreparable harm is perhaps not obvious. They have to judge in another court for some time, but they could come back. So it's a period of time. And for me, the problem, if I look at the whole picture of the court, almost all human rights violations create such a problem. So some people have to wait for 8 years for their cases, and some get an intermediate measure within 2 days. And how can you, with the 60,000 complaints coming in every year, then distinguish which goes in this direction and which goes in that direction? So personally, I'm reluctant with this interim measures. It's a very sharp weapon, and it's a very good weapon, but it has to be used very carefully. And I was very surprised when I saw how the court uses it. I understand why, because it's an alarm bell shrilling. That is what I have said. But at the same time, it opens the court to criticism, I'm afraid. But to your question, yes, they should stay, and that should then, this idea should apply to other cases as well, because it would be the same, so other judges in the same situation, they could come to the court, and the court would have to apply the same interim measures. Yes.
Mam wrażenie.
Well, I think we need a quick reply to that, sir, Professor. Yes, I would like to add a comment. Well, the Ministry of Justice, to the best of my knowledge, what I have learned from the best possible source, which is those interested in the resolution, in the judgment, the Ministry of Foreign Affairs in Poland have sent to Madam President of the Court of Appeal, the Mr. It was him, like the President of the Court of Appeal, they sent him the decision, but only with regard to the part which says that in the future you cannot remove or transfer people against their will or without their consent. So to put it in other words, this is a case where the authorities of the Republic of Poland, well, either they can read a decision only in the second half of it, they cannot read the first half, or maybe the first half, not the second half. But this case is quite interesting, because you have to read the entire decision from start to finish, read and translate it into Polish from start to finish.
Perhaps just a word, interim measures are never for the future. Interim measures are measures for the present moment. So the idea of interim measures is only to allow the court to decide the case before the consequences are already zero of the judgment, because everything has been done. So it would be against the very idea of an interim measure to apply it only to future cases. It wouldn't make sense.
Thank you very much. Yes, we had a question here, so let's continue before we run out of time. Good afternoon. My name is Wojciech Kostecki. I'm a professor at the Warsaw School of Social Studies. I will speak and ask a brief question. As a politology expert and a proponent of constructivist theory, especially the two threads of your presentation, Madam Professor. The first one about independence or the rule of law, to put it more broadly. So the question is, can you define, or to put it more broadly, can you define one and only vision that's good forever, once and for all, speaking about independence. Maybe it's more relative. Maybe we should admit it is more relative. Maybe we should restrict it to a given time and place. Spoken by a politology expert, political sciences expert. I think Turkish, French, Russian, or Polish judges, they do have 4 different takes of independence. I do apologize for all those who feel offended by what I said, but I think the level of sensitivity is different in each of the 4 countries, for example. So some of the rule of law, even a little bit of a rule of law, a little bit of independence would be good news for some country judges, and then as a next step they would fight for more. Is there one universal definition of judicial independence and autonomy? And my second question is about the ordinary citizen. In Polish, ordinary citizen, the word ordinary is like maybe average or maybe regular. It doesn't sound that positive. It makes me feel as a political science expert as if it was an anonymous group, a population that knows nothing, see nothing, they have no skill, they have no knowledge. But this group is quite diverse. They are not ordinary people, they are not average people. These are the people who have their own identity, their tradition. They might be committed to a bigger or smaller degree in lawmaking or in politics. So me, an academic, why would I be referred to as an ordinary citizen? I think I do have my special features. I have had some contribution. I like to tweet nasty things, nasty to the ruling party. So I hope you can understand where I come from. Thank you. Thank you. Mrowicki, Dr. Mrowicki, PhD, also wants to take the floor. Good afternoon. My name is Marcin Mrowicki, the European Center of University of Warsaw. I have listened intently to Professor Nussberger's lecture. The jurisprudence of European Court of Human Rights is indeed very interesting, but I happen to be quite critical because of simple statistics. So far, 8 judgments have been delivered, and in October there were 195 cases on the rule of law, 195 cases. So you could have taken a more comprehensive stance. You would have been more anti-authoritarian or anti-authoritarianistic in your policy. There was a Grzenda case. I used to believe very, very strongly that maybe in that Grzenda case you would have taken a more radical stance, more inquisitive, more in-depth. Maybe you should have taken a few cases together. Maybe you should have done a pilot judgment. You haven't done that. You take each case one by one, each of them separately. So the time that it takes to deal with a case, it's running out. The cases are flooding in. There's a pile of cases. We have so many new problems about the disrespect for the rule of law. As Professor Wrzykowski, it's too late anyway. It should have been done yesterday anyway. On the other hand, there seems to be quite a strong resistance from the government. The government, for example, I mean the government body, the Constitutional Court now, it's a government body. They have now delivered 2 judgments which contest the constitutionality of Article 6 in the interpretation that you can read in the European Court of Human Rights jurisprudence. We have rejections, refusal to pay compensation that has been adjudicated by the European Court of Human Rights. So it's like a clinch now. And here is my question. Do you, and if so, how would you see the follow-up work by the European Court of Human Rights? What should the court do in the context of such resistance by Polish authorities and the mounting problems? Thank you. Thank you for your question, sir. I think now is the time to give the floor to Professor Biernat. Sir, can you please say a few words? I'm not sure how we do it technically, but I think in a moment we're going to hear Professor Biernat online. We cannot hear you, sir, not at this moment. Is it going to work? Well, Madam Professor, my question now in translation. How do you perceive mutual links or interdependencies between the jurisprudence of 2 European courts? I'm talking about the case law on court independence and impartiality of judges. I'm talking about the Strasbourg court and the Luxembourg court, of course, because it's clear to see that there are some interdependencies when you look with an outside view. So what is your in-depth thought on that, madam? Thank you. Fair enough. We have run out of questions, I believe. So with that, Professor, over to you. The floor is yours.
Yeah, thank you. Thank you very much. It's always good to be in an interdisciplinary dialogue, and I see that the approaches are different, but the questions asked are always the right questions as well, and interesting questions. So the very idea of having a convention for Europe is that it's possible to have a yardstick that applies to all in the same way. And so we do not distinguish and say in Azerbaijan independence means something different than in France. So for a court like the European Court, we have one yardstick, and that's the convention. And independence means freedom from pressure. Whatever this pressure might come from, if it's small pressure or if it's strong pressure, there should be freedom from pressure. And judges in all the situations should have the same possibility, like the Polish judges, to bring their cases as well to the court. So that's the European approach. You might say it's naive, you might say it doesn't work, but I think we have now more than 70 years of jurisprudence where you see that what is a case in Hungary and what is a case in Azerbaijan can then be discussed further as part of the case law in another case concerning Germany. So we do work with a yardstick, and I think in independence we have clear criteria where we say somebody's independent, and we have no lower standard for judges who are not used to independence because of the history of the country, but the idea is the same for all. And you talk about the ordinary citizen, yeah, the word ordinary, of course everybody is different, but as lawyers we have to sort of identify the specific role in which somebody comes to us. And so the ordinary citizen is for us just an applicant or a complainant. And whatever merits he or she has, I just look at them as complainants, and I look with their specific human rights complaint. And that's the only thing that interests me about the citizens who come to us. I don't know if that's a fair answer, but that's the answer I can give as from a legal perspective. Now, the question about sort of judicial politics and what to do about what we call principled resistance. You know that in the first years of the court, it was the world was still not really a paradise, but probably better. So judgments were implemented. And nowadays we are faced more and more often that judgments are not implemented. And we have coined this word principled resistance. So it's not just not implementing, but principled resistance. And that's what we have seen with the Polish Constitutional Court arguing that Article 6 in the interpretation is not part of the legal system. What are the tools? Well, you have mentioned yourself, a pilot judgment, of course, would be possible. And you are perfectly right that the court is overburdened. It's not only overburdened by Polish cases, but we have illiberal developments in many countries. So the court is overburdened very generally. And it has to divide its attention to all the burning problems in the world, not in the world, but in Europe. And it might be a possibility to have a pilot judgment to group several cases together. I think there was a long delay in dealing with the Polish cases, which was very deplorable. And I think during that time, the Venice Commission was much more active and others were more active. That was very deplorable in my view. But then now the court started to really deal with those cases. But yeah, you are right. They are sometimes more than 100 pages and it takes time and it may be too late. But concretely to your question, what can be done against this principled resistance? There is a remedy in the convention, and that's Article 46.4. So the Committee of Ministers has to decide that Poland the question of the implementation of a judgment has to be brought to the court once again, but that's a very dangerous path, because it may lead to the expulsion of the member state. And we had, while I was still at the court, we had the Mamadov case where Azerbaijan then released Mr. Mamadov, but they played with us, but in the end they released him. Now we have in Turkey, we have the, what the name of this medicine, we have the case where we have a violation found and Turkey does not react. So this is an absolute, a real challenge to the whole convention system. If you use the sharpest weapon you have and then there is nothing happening, but the answer is clear. So we have this instrument, and the idea is to bring the case, the non-implementation, to the court. The court decides, and if it says yes, there is a question of non-implementation, then it's the political decision to expel or not expel the country. So it's not without any possibilities and measures, but of course nobody wants member states to leave the convention, because those who are protected by the convention, it's the worst that can happen. So that's always the dilemma, and that's why this mechanism is used so rarely. And concerning the two European courts, well, the two European courts, they have their story of relationship like in a marriage. Sometimes they love one another more, sometimes less. I think in the Polish case they love one another more, so they at least they quote one another all the time. And that's perhaps also because it's such a delicate and difficult question. As I have told you, it's not always straightforward. It's always, you have to take quite important steps in developing the jurisprudence. And if you know the other European judges are at your side, that's helpful. And that's why you see quotations over quotations. And there, I think the European understanding is really, we have to speak with one voice. It does not always function, because different judges have different opinions, but it functions, I would say, quite well.
Thank you. Those answers. I think that those two courts love each other so much regarding Polish cases, because there is somebody in between, like the Polish civil society, judges, members of academia, that are flooding both courts with cases and some ideas for interpretation. And basically this conference is about this, about how to contribute to the rule of law by just giving the chance those courts to deliver important judgments. Ladies and gentlemen, Professor Nussberger, thank you very much for your contribution, for your keynote speech, and for the discussion. Thank you.
Now let me give the floor to Dr. Filip Skawiński. And I'd like to thank you very much again, Professor Nussberger and Professor Bodnar. Dr. Filip Skawiński, Deputy Head of the Political Section of the European Commission representation in Poland. Filip, over to you for the presentation of the book that probably everyone has already seen and maybe even is holding in their hands. If not, please help yourself. Yes, indeed, today's event is built around two happenings, two events. The first one was the fantastic lecture of Professor Nussberger and the discussion, and the other theme is the publication of the third volume of our publication documenting the issue of rule of law or disrespect for rule of law in Poland. And this is confirms the fact that the issue of the respect for rule of law in Poland is getting more and more serious. We already have 2,000 pages documenting these issues, but we do want to present it to you and tell you a little bit about how it was created and what you can find out. So it will be like a meeting with the authors. Of course, we're not able to bring together all the authors, 18 people, but the three editors, Professor Jan Bart, Professor Agnieszka Grzelak, and Rafał Szendlauer, please take your seats here. So these three people have been the pillars of the book, and we will be talking about this publication, but I expect that the discussion may also go in some other directions, not necessarily just about the book, but also about the subject matter of the book and its contents. You are very good specialists on how to observing and diagnosing the medical record, if you like, that is really the contents of this book, that is the issue of the violation of the rule of law, and particularly the independence of the judiciary in Poland. Professor, can you tell us a few words about the concept that was the foundation of the construction of the structure of the third volume? Well, we divided our tasks among us. We've divided our tasks in such a way that I wanted to tell you about the methodology a little bit, where this idea for this project has come from. Professor Agnieszka Grzelak will tell you about the main themes, the main subject matter themes in all those volumes, and Rafał Szendlauer will talk about the broader context. So the issues that the Commission has to deal with in the context of the rule of law, or the problem with disrespect for rule of law in Poland, as well as the new mechanisms that have either accompanied the jurisprudence of the ECJ, or at least they play an important role. So first from me, a few words about the origins of this project. It goes back to 2017, because that was when the stage of political dialogue ended, the dialogue between the European Commission and Poland as part of the communique of 2014. And we all know that it ended with the application to the Council to launch the formal procedure under Article 7.1. At the same time, the year 2018 was also the time when the European Court of Justice started to refer, mainly in the cases related to Portuguese advocates and in other cases, making references confirming the relevance of the rule of law in the European law. We know that that's something that was questioned both by Hungarian and Polish governments, saying that it's not really included in the treaties, and it also referred to that when talking about its own jurisdiction to deal with such cases, particularly involving the independence of judiciary and impartiality of judges. Professor Zawicka couldn't come here, unfortunately, but then, it was then when a smaller project was born that ended or resulted in two conferences and two publications. One was analyzing the application of the Commission's application to a request to the Council, and the other one to the judgments of 2018. And that was the starting point for building this huge project, which at that time in our discussions was based on three main assumptions, substantive assumptions, which also had impact on the methodology of the project. So first of all, we could state that here in Poland and in Hungary, we are not dealing with some incidental infringements on the rule of law that can be easily remedied. No, we're dealing here with intentional, purposeful shifting away from the rule of law and conscious, purposeful building of an authoritarian state. Secondly, we've stated that if such countries start to appear among the EU member states, other member states are simply helpless, particularly the procedure of Article 7 that was created in order to respond to incidental infringements of the rule of law rather than what we were facing, we were witnessing. And thirdly, in 2018, we could already see that what we are left with as an effective path to take was the ECJ and procedures under provisions on violation of treaties and referral of questions for preliminary rulings. And that was the basis of that project. The first volume covered materials related to political dialogue. We've decided that in spite of the fact that the case was over, we decided that still that material was very valuable and worth putting together and writing some comments on it.
We also have some excellent analytical work of the Commission, some recommendations for the Polish government, but they are not sufficient because in parallel, as you might remember, dear friends, we had excellent quality of analytical work of the Venice Commission and other international bodies, NGOs, that were, preparing submissions in connection with what was happening in Poland and in Hungary. And that's how we have developed a volume that really went beyond the EC material alone. But during our discussion, to be brutally frank with you, when we were, considering it, there was a very bitter comment or a bitter pill to swallow, because these documents are beautifully written, very professionally, but this is like a very professional post-mortem report on a dead Polish rule of law. I'm sorry to say, the other volume, there are some copies, so help yourselves. It's the jurisprudence 2018-2020. It's a momentous period of the first 2 years when the case law lines were being solidified, some definitions were getting established and solidified. So when you look at that volume, you will see that we had to go beyond the Court of Justice case law. First of all, we had to get a full set of jurisprudence in Poland. Second of all, we had to comment it diligently and fairly. Thirdly, we had to present a context. So you will see the judgments of the European Court of Justice on other matters, but always related to the rule of law and respect for the rule of law in a member state. But we also noticed that we would have to include the jurisprudence of European Court of Human Rights, as that court started to look into that more and more intently. What else was noted? We had to pay attention to new mechanisms that were emerging in the European Union, because the European Union could not stay idle, as you know. They initiated this soft mechanism of monitoring and reporting on the state of the rule of law in every member state of the EU. And this is not to be taken lightly. This is not to be looked down on. People might not be enthusiastic about it, but they should be, because it's an excellent foothold for domestic courts and other institutions, including EU institutions, when it comes to solid diagnostics of the status quo in different member states. It's really important. Look at what's happening with the European arrest warrant, the ENA. Look at the implications, the hard implications. What else did we have on our minds? We realized we have to include the documents of other EU institutions, such as the European Parliament and other international players. That brings us also to volume 3, the one that we are happy to present today. It is not our fault that this volume 3 is actually made up of 2 volumes. It's 2,000 pages. It was the only way, okay? There was no avoiding it, because in that third volume, made up of 2 volumes, we've also decided to include to a much higher degree the jurisprudence of the European Court of Human Rights. It was a must-have. It was necessary because, you know, talking about human rights and protection of human rights, this jurisprudence, these two courts, they like supplement one another and they influence one another. There's a lot of linkages between them. We also decided to expand the section dedicated to the reaction of the governments. And in the second volume, in the third volume, you will see the political positions, a summary of government submissions for two reasons. First of all, to hear the arguments, and second of, not to let us forget anything. The future generations will want to come back to it. They want to see the degree of arrogance, the degree of disrespect for the rule of law. They will be astonished to see how far it all went. And in that context, in volume 3, we decided to include a very relevant item. It's relevant for us, it's relevant for all the commentators, those who look at what's been happening in Poland, in Hungary, the documents from other institutions and NGOs. What do I have in mind? Well, in that volume you will be pleased to see the reports on what's happening on the Polish-Belarus frontier. This will be a pang of conscience for the Polish state for many years to come. It will continue to haunt the European Union for years to come. And at long last, thanks to our exemplary collaboration with the colleagues employed at the Ombudsman's office in Poland, we decided to include not all of it, but at least the top documents that the Ombudsman submitted before the European Court of Human Rights and the European Court of Justice. And most of that has never been published before. It has not been available to the general public. And that brings us to yet another mission that we have. I think we'll discuss that aspect of the mission towards the end of the panel. But I have three final comments of a more like acknowledgements and recognition. Well, first of all, in the last few years, we had almost 40 academics and practitioners who specialize in the rule of law and all the problems we are confronted with now. I suspect that, well, to the best of my knowledge, this is the biggest academic/pragmatic or practical project ever done in Poland for non-public funds. Well, non-public, I want to say non-government funding. That's a better way to put it. So I think a big acknowledgement is due for all the authors. It definitely took a lot of self-discipline. It obviously took a lot of expertise and a lot of goodwill. You know, all the comments you will find in the publications, you know, that it had to be drafted by hard-working people. And my second point is that there was a common denominator to the project. And what was that? Well, that was the representation of the European Commission in Warsaw. I want to say it out loud. Without their support, starting from those tiny project 2018, all the way to, or through all the volumes, you know, without the representation, we wouldn't be here today. I believe a lot of appreciation is due to Mr. Marek Prawda, the ambassador. I hope he's still with us now. Over many years, Marek Prawda has been instrumental. Thanks go to Marzena Usweter. It was definitely under your umbrella, madam, that we could finalize that effort and that volume over the last few months. We are really thankful. A perennial dream of all editors and authors is to be able to complete that series next year with volume number 4. Volume number 4, which will include 2022 and 2023. And the final chapter would be dedicated to like a wrap-up of all the projects. What do we do with this untasteful dish that our government chefs have cooked for us. This beverage that has been brewed, and we have to drink it now. Well, no acknowledgement would be complete if I didn't mention Włodzimierz Ulicki, PhD. He is the director of the publishing house, and the publishing house did all the work behind the scenes. It was no easy challenge. We did work on it until the last day. We were adding things, removing things, etc. So now over to you, Professor Grzelak. Thank you, sir. Well, ladies and gentlemen, thank you for having me. Thank you for letting us present this publication, which is not very user-friendly. It's getting more and more voluminous. We'd all be happier if it had never been written. We'd all be happier if the problem had never emerged. There are so many technical subjects that we had to omit or downgrade in the publication. We just had to restrict it to the administration of law without other aspects of the rule of law. We didn't speak about the freedom of the mass media. Hardly anything have we written about the rights of the fugitives or refugees of war, the legislative procedure in Poland, the mode, etc. Back in 2016, that aspect was raised by Professor Wyrzykowski, but I'm sorry, these topics just physically, we couldn't squeeze it in. And yet these are topics not to be forgotten. How can I summarize 2021 in a few words, given that we have over 2,000 pages that we're looking at? Well, the only way to wrap it up is to name some bullet points, to name the fundamental problem issues that have surfaced in the jurisprudence of the European Court. An excellent chapter by Ms. Doczekalska, PhD, who is analyzing European Parliament resolutions. They are included there verbatim, so I encourage you to read them. So 2021 was full of technical problems that actually dragged on all the way to 2022. They are still pending, in fact. So let me summarize that. I have my sequence to take 10 minutes instead of 60 minutes, so I have to be really disciplined. I have a couple of notes. So topic number one, of course, is disciplinary proceedings against judges and the immunity lift proceeding. It's a very relevant problem, relevant and unresolved. Just this week we had a case of Madame Professor Gersdorf and the accusations against her by the disciplinary officer. And yet in 2021 there was a fundamental judgment, EC versus Poland. It was Professors Barcik and attorney at law Mr. Wróblewski wrote 2 chapters on it. It was the third complaint of the Commission about the disciplinary system in ordinary courts of law, the Supreme Court in Poland, including the increased influence of the Minister of Justice on the operation of disciplinary officers. One of the allegations raised was the issue of qualification of the content of a judgment as a disciplinary offense and the lack of disciplinary procedure standards. These standards were not adhered to. Let us remember about that, because these cases continue to pop up, and the judgment went one way, and yet the practice goes the other way. So we had to continue this topic because of lack of reaction to this, and the prior judgment. There's another complaint of the Commission that has its roots in 2021. It's C-202/21 about the muzzle law. Next week, to the best of my knowledge, the opinion of the Advocate General will be published on Thursday, yeah. April 1st, 2021, the EC decided to lodge an application against Poland. This is about those, key allegations on the content of the law. The text of the law, I will spare you the details, you all know what I mean. But it should be emphasized that there are some cases that were already dealt with by the Court of Justice. It's about persecuting the judges, transferring them to other courts. The WZ initials That's the victimized judge, Ms. Wojek, wrote about it. So that kind of neatly brings me to the second topic, the issue of the disciplinary chamber in the Supreme Court and the nominations of the judges or judge appointments in the new system and the operation of the National Council of the Judiciary, the NCJ. For example, the judgment of March 2021, the AB case, as Professor Wyszkowski said, it was initiated in 2019. So all the information has been laid out, it's out there on the NCJ, its positioning in the system, the opinion of both courts when it comes to the NCJ, and yet no change, yet business as usual. I need not remind you of all the reasons why the courts pointed the reason with the in the independence of the disciplinary chamber. In 2021 cases, also the Court of Justice reconfirmed all prior judgments, the ones that were included in the prior volumes of our project. That brings us to interim orders. Interim orders, the 402 million euros that are now on the counter and counting that Poland has to pay because of this interim order dating back to October 2021. Not because of the interim order, but because it doesn't observe what the order says.
The financial consequences, and we've already started to feel it because these funds are just deducted from the funds that Poland should receive. The issue of a disciplinary chamber has become one of the milestones agreed in 2022, and still, in spite of all this, the disciplinary chamber was still operating in 2021, continuing to suspend subsequent judges because of disciplinary proceedings against them or waiving their immunities. We were also writing here about different procedures that took place after those judgments had been issued. The issue of disciplinary chamber was also the subject of the work of the European Court of Human Rights. Dr. Filipek was dealing with these issues in the Ombudsman's office, so I do encourage you to read that particular chapter. And all this brings us to, or leads us to theme number 3, which is the issue of the rulings on interim measures and their application. Dr. Kawczyńska writes about them very broadly in our book, and she tells us about the legal foundations, and she debunks the myths that there is no legal basis for awarding such interim measures. And let me remind you that here we have the response of our so-called Constitutional Court to that. Also, the coincidence is also important here if we think of what was happening in July 2021, when day after day we had the judgment or the decision of the so-called Constitutional Court issued, and then we had the muzzle law decisions, and then the issues related to the judgment of the ECJ concerning the disciplinary procedures. So we're writing also about the sequence, and the interim measures is something that the so-called Constitutional Tribunal or Court is still dealing with this. And that leads me to theme number 4, which is the theme related to Constitutional Court, which, in spite of a lot of doubts as to its legitimacy, is still continuing to issue decisions or judgments on the challenging, for instance, the primacy of the EU law or provisions of EU treaties or the European Convention on Human Rights and Fundamental Freedoms. these decisions of 2021 are described by Professor Wyrozumska, K3/21 and P7/20, where the Constitutional Court judged that one of the articles of the Treaty of the European Union, Article 19 of the Treaty of the European Union, is inconsistent with the Polish constitution within the scope of certain contexts. That was then continued in 2022. We had subsequent cases, 6/7/21, when the same body, the same court, stated that the Article 6 of the Convention is inconsistent with Polish constitution within the scope, as it authorizes the court to examine the legitimacy of the selection of a judge. And the response to those decisions and the response to the problem that the Constitutional Court of Poland poses, the European Commission, bearing in mind those European Court's decision and the general situation related to the operation of the Polish Constitutional Court, decided to launch the procedure, which is now pending. It is not yet at the phase of the application against Poland being filed to the court, but we do hope that this issue one day will also be resolved by the European Court. What must be remembered is the fact that both the July, I would say, judgment excesses of July and October by the Constitutional Court, they state the unconstitutionality of European provisions in an absolutely outrageous way. No other domestic court has ever decided to challenge or question the EU law in a similar way, and I do encourage you to read the chapter by Professor Wyrozumska dealing with these issues. There are also other issues that are discussed in the book, the mechanism of conditionality. Professor Watzna writes about that. There is another chapter about the media, prosecution service, finance, women's rights. Also the fact that Poland is not part of the European prosecution service. But if we wanted to discuss all that in detail, that would mean that we would have to spend much, much more time here, which is simply not possible. But just to conclude, let me draw your attention to just one subject, which is so important here, which we included in the attachments because it was just not possible to write more about it, which it really deserves. It really deserves a separate publication, really. That is the issue of how people looking for protection in the Polish-Belarusian border are treated, and also the treatment of people who provide them with assistance. Because that's also the reaction to the fact that Polish citizens help those refugees and what kind of shape this reaction takes. In my view, but it's also the assessment of Professor Bodnar, with whom we are now working on a text related to those issues, this problem must be the subject of much stronger reaction also by the European Commission than it has been so far, because we have reports, we have interim measures or orders issued by the European Court of Human Rights, and we know for certain that human rights are regularly violated there or in a very brutal manner. Dr. Machińska is no longer with us, but I would also like to mention her here, and I encourage you to discussion, to your comments, maybe not as so much as to the facts, because we all know what's happening and what our positions are, but I would like you to encourage you to a discussion to what we should devote the next volume to. What are the issues that we should pay particular attention to when thinking about the next volume. Thank you. Okay, yeah. Let me just take this opportunity and just refer to what the two of you have just said from my personal perspective. Because working in the European Commission, I have this comfort that I can sometimes participate in the actions of the European Commission related to those issues. And I do remember something. I remember a discussion I had with the advisor to Deputy Commissioner Timmermans. It was in spring 2020 when the dialogue was still on, and it seemed that if there was enough goodwill on the part of the Polish government, that dialogue could have led to solution when the issue was only the Constitutional Court. And I say to this advisor, if we of the Commission say that what we're dealing here with is the infringement of the EU, violation of the EU law, maybe the Commission should really use the infringement procedure. And the response I received then was, well, no, perhaps not. This procedure is not really no good here because we've got Article 7. The infringement procedure is rather technical. So the Commission probably won't risk applying this here. We know that everything has changed after the judgment on Portuguese judges. And I remember a visit, and that's one of the activities of the representation of the European Commission, just to facilitate the dialogue. When we had a visit of the legal professionals, Polish legal professionals in Brussels, some of you here also participated in that visit. There were 3 such visits organized. And I remember Mr. Timmermans in Brussels that time when he was saying what Commission does, what the Commission could do. He referred to the judgment on Portuguese judges as a landmark ruling, a ruling setting a new direction. And it does seem that from then on, the burden was on the judicial decisions, that the Commission had been asked to act, criticized sometimes for not taking action. I'm looking at Professor Bodnar here because I know that he, at some point, some occasions, was not very satisfied with the operation of the Commission, and all that was now transferred to the judicial platform, if you like. But let me just add one more sentence, because what you've just said, I think, shows very well the issue of the activity of Polish judges. I think that's something that we must remember. Without the questions referred for preliminary rulings, we wouldn't get as far as we have got in the jurisprudence of European courts. We have judges who, in spite of the consequences that they might face, they still decide and not afraid to formulate and to file their applications and requests to the European Court of Justice. And my chapter is about Hungary and Romania. Please have a look. The approach and concerns of judges in those countries are completely different, and I think the attitude of Polish judges is different. Yes, once when these times are just a bad memory, I think we will still have as a legacy their contribution into the development of the European judgments, and even in textbooks of European law, I'm sure those cases that were formed around the questions for preliminary rulings will be mentioned. But Rafał, there are also other instruments, out of court, more political instruments. Article 7, whose limitations we all know, which often is treated as totally useless or maybe not very useful to contribute to improve the rule of law situation. Please tell us, how do you assess the usefulness of those other non-judicial instruments? Well, the first thing is that we've got a lot of different mechanisms to protect rule of law that the European Commission and other EU institutions can use in order to protect the rule of law and ensure the respect for the rule of law. One of the most effective ones are the infringement procedures. There are a few of them. Some cases have concluded with the judgments positive for the European Commission. You know those cases. All those cases have been won by the European Commission. There were some cases where the Polish government just withdrew, anticipating the judgment, just withdrew from the dispute. So from some point of view, one may say that these mechanisms are effective, but there are also penalties imposed on failure to implement the interim measures, which are completely disregarded and ignored by the governments. These penalties are accumulating. I think TVN, which is one of the Polish television stations, they publish information. They have like a counter showing us how much money, how of the penalties are growing. But this is what we all know. Let me now refer to the two mechanisms that have gone off the radar. One is Article 7, which is generally believed that is the main procedure to be followed in order to counteract the violation of the rule of law or other European values, is generally believed to be completely ineffective, because in order to impose the sanctions that can be very serious, you can really suspend all the rights under the treaties, rights related to the membership in the European Union. But in order to do that, in order to impose those sanctions on member states for violating the rule of law, at some point, unanimity of all member states is required.
And it goes without saying that unanimity is impossible for a very simple reason. There are two countries which ostentatiously break the rule of law, and mutually, through their political leaders, they keep declaring they will protect one another. So that makes the procedure null and void, or ineffective when it comes to sanctioning the countries. And the question is, does this procedure make sense then in the present day situation in Europe? Well, if I may present to you the Brussels perception when it comes to this procedure, it turns out that the procedure, well, it is in place, it is quite alive and kicking, and it has its political gravity. What's happening? We got stuck at stage 1 of the procedure. The EC for Poland, they initiated the procedure, lodged an application with the Council. The Council is now processing the application. For Hungary, the European Parliament did it. If they hadn't done it, the Parliament had done it, the Commission would have done it. But the Commission, being aware of the fact that the Parliament was working on their own application, the Commission simply decided to not to lodge an application against Hungary. But at the end of the day, it all boils down to the same thing. Both countries are under the same infringement procedure. Hungary has a broader scope of allegations. Poland has a narrower one. For Poland, it mostly applies to broadly understood rule of law. So what is the follow-up in the procedure? The hearings are now being held in the Council. So far, there were more than 10 hearings concerning Poland. And there are two types of hearing. One type is a formal hearing. What does it mean? It means that it is announced that there is a hearing, and the member state, well, it has to present its official position, and then other member states, they'll do deliberations, they ask questions to the given member state, they inquire into the violations that were included in the application. what's going on, etc. These are the formal hearings. But on top of that, there are deliberations. There were a few formal hearings, plus every now and then deliberations are initiated on Article 7. So together, if you put together the hearings and deliberations, there were more than 10 so far. There's a lot of, as I said, political gravity to that in Brussels. Contrary to what you might hear, that it's irrelevant, no, it is very much relevant. Why? Because that builds political climate around Poland and Hungary. The mere fact that these two countries have to explain themselves in front of the Council, that's something to shame them. In Poland, you might feel that our authority is shameless and that they are not afraid to be shamed. But look, the fact that we have some explaining to do before the Council, believe me, those who do it, they're not happy or proud to do that. Far from that. They might try to look happy and proud, but this is not the case. So the climate of a hearing, the ambience, the atmosphere, it kind of spills over other decisions, political decisions to be taken in the European Union. Because what is the way that Brussels sees it? Well, let me be quite frank with you. In Brussels, not all political leaders dream and eat and talk about the rule of law in Poland or Hungary. No, they do not. Make no mistake. There's so many different challenges in the European Union, so many deliberations and discussions. So the leaders of member states, well, I'm just trying to say that they are not really living and breathing law every day among us, the lawyers. This is to be or not to be for us. We look at the judgments, the communications, the Court of Human Rights, Court of Justice. We take it very seriously. But for political leaders in a member state, well, it is a topic to be revisited from time to time. Let me put it this way. So a hearing before the Council under Article 7, it has its political gravity because all political leaders in the European Union at a given point in time, first they have to become familiar with the rule of law status in Poland and in Hungary, because usually the hearings are combined. It's Poland and Hungary together. So they have to be familiarized with it, they have to be briefed on it, they have to dedicate a lot of time to that. Then they have to ask questions and take some position to what's going on in Poland and Hungary. They have to ask questions to our political leaders who represent our country. And last but not least, the outcome of the discussion, well, the conclusions, which are usually in camera, and they are kept in confidence, but this like very interesting deliberation inside, but as I said, it's in a private hearing, and maybe the Commission will know what was said, but we cannot disclose it publicly. But anyway, the political climate, it means that the leaders come back to the countries, and based on the knowledge they get, and based on the climate, they will or will not take certain political decisions, which then translate into other EU policies and programs. So we can only presume, and we can only guess what would happen to the milestones in our NRP if it hadn't been for the awareness among European leaders who had to then give the green light to the milestones. And before that, they had to submit some, proposals on what to put as a milestone. So in my opinion, Article 7 has some political gravity, and it is relevant, contrary to what you might think. But when there is a change of cabinet, a change of authority, one of the two countries which have this PR and they say it out loud that they will not allow the sanction to any other country. But when the political authority should change in Poland or in Hungary, the other country will be in a different place. They will have lost their protective shield. They will have lost the shield which makes the political leader feel self-assured. They feel impervious to sanctions. I'm not saying the sanction would be mobilized right away, because you have to prove that there is a serious risk, that the fundamental principles from Article 2 are in jeopardy. Then there is a sanction procedure, and then you have to decide what sanctions specifically, etc. But it's not about punishing a state, okay, under Article 7. No. On the grounds of Article 7, it's about having a dialogue and removing the infringements without the punishment. The punishment is like something looming on the horizon, which is supposed to motivate those violators, those who violate the rule of law and other fundamental values. It's supposed to incentivize them to take their EU membership very seriously. So Article 7, in my opinion, now, like from the Brussels perspective, Article 7 is both relevant and it has some political gravity. And once the authority, the cabinet should change in Poland, maybe after the parliament election, this could bring on some specific legal implications as the procedure progresses, whether against Hungary or against other countries that violate the rule of law and other fundamental values. So that's all about Article 7. How are we on time? Well, we are behind schedule, but how much behind schedule can we get? Well, I think I have quite an... Okay, try to be brief, okay? Okay, so briefly. I have written a chapter on the new mechanism that safeguards the rule of law. What mechanism is that? Well, it's called the Mechanism to Safeguard the Rule of Law. That's the name. It's an annual review of the rule of law in every member state. And the crowning effort is a report, an annual report on the status quo, compliance with the rule of law in every member state. Broadly understood. Broadly understood rule of law, what does it mean? It means a review across 4 broad areas. And these are the judiciary, mass media freedom and independence, anti-corruption framework, or broadly understood corruption and anti-corruption measures, and last but not least, the balance of powers in the member state. So altogether, this is the rule of law mandate. And in our opinion, when these areas were formulated for the review, well, it all started because, first of all, these are the areas that are the most prone to some controversial issues. Second of, when you take a very narrow view at a rule of law, you are likely to omit some pertinent factors. For example, the freedom of speech in mass media, the way the mass media is being used or abused to create certain political climate, political narration, or to spread lies, to put the nail on the head. That will have its bearing on the rule of law as such. You probably remember this media campaign against Polish judges, right? Quite a dramatic example, full of lies, outright lies, and that was done with public money, wasn't it? And the public media were heavily involved in that slander campaign. So we have selected the 4 areas, and we have been reviewing the situation across all member states based on one single set of methodological criteria. Why do I think the report is so important? What was the spiritus movens behind the report? Well, first, what we had this respect for the rule of law in Poland and Hungary. For a very long time, the Commission was looking into the situation in those states with avid interest. And when during the dialogue with these 2 countries and in the dialogue with, public dialogue, some arguments could be heard that first the European Commission, then other EU institutions have set their mind to pester those two member states. Some arguments were that other member states also violate the rule of law, and yet the EC will be adamant just to stick to those two. Yet when you look at other countries in the EU, you will, I mean, if you took a proper look, you could also see it in other countries. Polish government actually published the famous white paper, a white paper where they presented their own reforms on the judiciary against the backdrop of solutions that apply to other countries. They have picked the worst infringements, the worst practices, country by country, and they laid it out in this white paper as a backdrop or as a comparator for the Polish reform. Well, if it were truth, so be it, but a lot of it was just taken out of context and it was misrepresented, I'm sorry to say.
Or it omitted some very important element that was of key relevance for a particular situation. So here we would really have to get into details, but that was the narrative. And we as the European Commission, we've decided to fight that, to counteract and to review, to prepare a very detailed review in those 4 areas in all member states based on exactly the same criteria. And as a result, we have an analysis which crowns a very complex process, which is now an element of a broader mechanism, an annual review of the situation in those 4 areas. And we, having this report in hand, we can say, yes, we have reviewed the situation in all member states, and it looks in the following manner. There are such and such infringements, and the reader can then compare himself or herself where the situation is better and where it is worse. Whether people will believe in the truth of that report, well, that's another matter. We believe that it's very reliable. We based it on very extended material, a lot of evidence, very detailed studies and analysis. And I described all that in the chapter that I wrote. So in fact, every word written in that report can be defended and then proven on the basis of documents or assessment of facts in a given member state, which is indisputable. And using this report, we can also defend against accusations that the European Commission is just persecuting Poland and Hungary and not doing the same, not responding to infringements in other countries. We've already prepared the 3rd such report this year. It's an annual report. We also formulate recommendations. So we not only list the infringements, but we also say what can be done in order to remedy them. Of course, it is not a legally binding document, which means that, well, someone might say that it's completely irrelevant, but this is not true. It is relevant, both as an analysis, but also has political meaning and analytical significance, because it offers a very detailed, factual analysis of the situation in the member states and maybe the basis for further discussions, leading to conclusions, some of which can have a legal effect. It also has political significance because this report forms the basis for taking a number of decisions in different areas, which result in action taken both by the member states and the EU institutions, and decisions that are made on the basis of the report. So the report itself is not legally binding and does not have legal effects, but an EU regulation that may be adopted on the basis of the legislative process that and the regular legislative procedure may be the result or consequence of the conclusions included in our report and a consensus between the member states and the European Parliament resulting from that. Okay, yes. Yes, I'm trying to let you know that we still have to maybe save some time for discussion, for questions from you to the panelists. Let me just add that Polish government decided to withdraw from the work on such a report concerning Poland because they say, again, there are no legal basis for preparing such reports. That's what the government says. Do we have questions here in the room to our panelists, maybe comments as well? Oh, okay, I can see one. Let's try to get to take few of those questions. We can't really afford long discussion. Bartłomiej Dąbrowski from Wolne Sądy, Free Courts Initiative. I have just one comment and a question. The question is the following. According to your knowledge, expertise, and the report, do you believe that those milestones in the context of the National Recovery Plan and restoring judges to their previous positions, Judge Laskowski and Judge Tuleya, are those milestones, in our view, can they be deemed by the Commission to have been achieved? And the comment is, Professor, you've mentioned, Madam Professor, you've mentioned about suggestions, or a question about suggestions, what should be included, what should next volume should cover. I haven't read the current report yet, but I think what also should be mentioned are prosecutors, because of course judges were their issues, their cases were very widely publicized, but I think what happened to some of the prosecutors, such as Prosecutor Wrzosek, is also something that calls for some description. The question was not addressed to any specific person. Of course, the milestones is more of a Commission issue. We, as Commission officials, we are not completely free to talk about these issues, to discuss these issues. I can refer to the other issue. Yes, prosecutors, that's the theme that we also have on the radar, although we were looking here on the jurisprudence, and this issue is not really visible in the jurisprudence, in the body of judicial judgments. But this is something that we do agree that requires attention. As regards milestones, well, that's something that I really don't want to talk about. For various reasons, I can't describe the situation related to the functioning of the Supreme Court or disciplinary chamber. I have to ask you to answer that. Okay, so let me respond, but let me make a reservation that I'm on leave today and I don't have a mandate to speak officially on behalf of the European Commission. Well, let me say what I think and how I see it. But last week, okay, I took leave last week and I'm on leave until Tuesday. So I'm on leave right now, on vacation. So as regards the acceptance of National Recovery Plan and payment of funds under that plan, the situation is the following. The plan has been approved. There are milestones included in the National Recovery Plan, and Poland is not any exception here. Every country has received those milestones because this money, these funds are to be spent in a specific way to meet specific goals. So milestones have been formulated in such a way that every country has been assessed, its needs have been analyzed, and a decision has been taken to say how they can best use the recovery and resilience facility in order to reach its targets. So every country has its national plan. In Poland, it's the National Recovery Plan, KPO is the Polish abbreviation for that, and there are certain tasks listed there that needs to be fulfilled in order to get the money, to get the funding. Poland has that plan approved, but it's not, Poland is not implementing those milestones. So the projects under the plan can be implemented because the plan itself has been approved, but the EU funding can only be paid once the milestones have been delivered. So we have a problem here because there are quite a few of those milestones. The most controversial ones again relate to the rule of law, but they are then again the simplest to deliver, because what it takes is just to introduce changes, legislative changes, which can be done without any additional costs, can be done very quickly. But for political reasons, Poland has not been doing that. So what is the position of the Commission here? Well, the Commission, we've heard that, for instance, from Vera Jourova publicly, so I can just repeat that. So the position of the Commission is that everything has been agreed, everything is in writing, now is the time to deliver. It's been agreed with the current government, which has agreed to all that consciously, right? So right now it's just not possible to open any negotiations related to the National Recovery Plan, because all the negotiations have already been completed and closed. The plans, the national plans have already been closed, approved, and the room for political maneuver for the Commission is very limited. So is it possible to agree to or accept the violation of fundamental European values? Not really. So in order to get the funding, all that it takes is to deliver on what has been written down in the Polish National Recovery Plan. So that's the current position of the European Commission. Programs can be implemented, but for the time being have to be funded from national funds, domestic funds, once the milestones are delivered and the Commission issues the positive decision, then the payments will be launched in the same way as it normally happens with EU funding. So we only pay after the project has been completed. With the National Recovery Plan, there were also options for advanced payments. This is not a usual practice with structural funds, but with the National Recovery Plan, it was different fund. It was funds for recovery of economy after COVID, but Poland has already lost this opportunity. And that was because the delivery has not happened. All other countries apart from Hungary have done that. So again, one might think why everybody else in the entire Union can do that, and it's only Poland and Hungary that are unable to do that, the countries that theoretically are facing much greater challenges. There are countries where implementation of milestones was simply difficult, because there were a lot of problems to be solved, and the problems that could not be solved just like that. In the case of Poland, the solution, or most of the problem, only requires political will and a quick procedure in the parliament. And we know, we have seen that if there is political will, the parliament can operate very quickly. I'm not on leave, and the question is very difficult. But so let me hand over to my boss. Well, I'm not on leave either, so I just wanted to add that the milestones cover several hundred of pages. In most cases, there is an agreement between the Polish government and the European Commission, and the Polish government has already delivered on most of the issues. We are still in dialogue with the the Commission is still in dialogue with the government. We don't have a situation when we're not talking. We've achieved a lot of progress as regards all of the issues, except for the rule of law issues. Milestones related to the rule of law are just 2 pages in the National Recovery Plan, but they are very relevant, very important, and they cover issues such as abolishing of the disciplinary chamber, which is happening, but as my colleague has said, there are still issues that are the bone of contention between the European Commission and the government, mainly concerning the disciplinary status of judges and the right of a judge not to be punished or prosecuted if he or she challenges the status of another judge. But apart from those 3 main issues related to the rule of law, we still have the H10H Act related to onshore wind and some other issues related to environmental protection, which might be proceeded in the Parliament next week. Whereas what we have written in the National Recovery Plan as regards the rule of law, this is only a small part of the issues related to the rule of law in general. But the talks are still in progress. We can talk about some acceleration and the more willingness on the part of the Polish government to deal with this, especially after Minister Szymkowski has taken over. How will that be concluded? We will just see. We know that there is a political debate in progress in Poland. So that's all I can say. Okay, we have no time for just one more question.
Actually, the professor wants to take the floor, so over to you, sir. Well, I am on the Social Security Scholarship. It's for a lifetime, so I can say as I please. Be careful, sir. Please be careful. Well, I have 3 quick comments. The milestones on the rule of law. We can approach that like step by step in this fragmentary way as they do it in discussion, but it's the wrong way, because it's a tip of the iceberg, and meeting the milestones is just reinstating the rule of law in Poland. Let's be open about it. Then the implications, what and when, well, that's quite unambiguous. There is a way out of the conundrum, because you cannot refuse the money to those who operate quite well, who follow the rules, local governments, local government bodies, various civil society units. So you have to operate in a more selective way. And these arguments have been heard a lot. We have to bypass the central government authorities, which are politicized. They try to manipulate the money for their own reasons. And now, on top of all that, this manipulation is especially nasty because it can affect the election. And that is one of the foundations of democracy that is now put at risk and deprived of its inherent value. So that's my comment. Now, briefly about what should be. It's hard to predict or anticipate what the next few months will bring before the election, and it's hard to predict how the election will end. But for sure, we will be holding on to these 2 main streams. The Court of Justice, first of all, because a lot of judgments have already been passed or they are pending, and we have not referred to them yet. The European Court of Human Rights, yes, that continues to be relevant. We are not going to overlook the prosecutor's office. No, we have a lot of justice for the judges who remain independent, but even more respect, I believe, if that can be, the gradation can be used here, even more respect we should have for the prosecutors who operate in much tougher environment, and yet they are able to keep their dignity as the prosecution officers. So they deserve our attention too. And we will try to pay attention to other problems as well. I wouldn't know why, but this border situation, Poland-Belarus frontier situation, I find it so indecent, so unhumanitarian. It totally goes against every fundamental standard of international law when it comes to the treatment of refugees from various parts of the world. So that has really kept me sleepless over many nights. And now, a final comment about Article 7. Article 7 has its merits. As Rafał Schindlauer said, I agree with him, it's an excellent conveyor belt for other member states to hear what's going on. But it's impotent, in a way. As a lawyer, when you see such an impotent procedure, a procedure doesn't bite, you obviously feel frustrated. So if a treaty can be revised when there is an opportunity for treaty revision, you should revisit the proposals that had been bravely rejected by the member states before. Namely, the question, is there a risk, is there a threat to fundamental rights? The Court of Justice must decide, not a member state. Potentially, as an alternative, the sanction phase can be indeed preserved in the hands of member states. But the lesson learned the hard way in the last few years is that this mechanism should have teeth, it should bite. Look at Hungary. They behave like a rogue. They use blackmail, blocking the money for the Ukraine, saying no to sanctions just to squeeze the money out of a different department that they are not eligible for because they disrespect the rule of law. So if the Article 7 performed properly, they should be suspended, the right of voice should be suspended, and then the other member state should decide. And as it is now that 2 member states are under infringement procedure, the lawyers in the council services can deal with it very well. These 2 countries would be exempt. They would have to exempt from the violation, I mean, from the, voting. When one of the states is being voted on, then the other state should be silenced. Well, I'm a timekeeper here. Timekeeper, we are 36 minutes behind schedule. 36 minutes. You would like to continue deliberating. You have the right spirit, but please let me take the steering wheel in my hands. Professor Wyrzykowski is now setting me off my track, putting a poke in the pie. Well, the prosecutors were referred to, so maybe Jacek Bilew would like to speak briefly on that. Professor Wyrzykowski and another professor, but can we please just agree to give each of you 60 seconds, 1 minute, and please do not respond to that unless you are mentioned by the name, and then you have to respond, okay? Because we do not want to drag it on any more behind schedule. In fact, I wanted to be the last one to speak, but I can recall Timothy Snyder, his second lesson. He had lessons for from the 20th century. Timothy Snyder wrote, "Respect your institutions." We now can see it, the institutions being weak, being degraded, being destroyed. But you know, when there's in Poland, but when there's destruction, there is construction the other way. So the volumes we have received today, they actually help to build a very important social institution, an institution that helps create the bonds of trust in the society. And without trust and confidence in the society, we wouldn't get any far. I also want to mention Wiktor Osiatyński, Professor Osiatyński, who liked to quote Miłosz. Everything you say, everything you do will be recorded. It will not go unnoticed. There is an archive dedicated to his name, an archive which joins you in your effort. So the archive and you operate complementarily. So you remember what Professor Osiatyński said, quoting the poet, Nobel laureate Miłosz. Those of you who do harm to the ordinary person, the everyman. Piotr Szczęsny wrote about it in his manifesto, and I think your precious volume should also be dedicated to those figures. Thank you very much. Jacek Bilewicz, lex super omnia. I totally encourage you to continue discussing the prosecutor's work. We only have the soft law of the Venice Commission and the Council of Europe. And you report on the rule of law, the recommendation on the first step to separate the office of the Prosecutor General from the office of the Minister of Justice. It helps us believe that you do not neglect us, that you keep looking at our situation. Everything you do is vital for us, because the 10 Commandments for us, the new Bible for the new law on the Prosecutor's Office, is the recommendation of the Venice Commission. So perhaps this will be a good starting point for the 4th volume, as Professor Bart was referring to, how to clean up, how to tidy up this mess. As a political science expert, you asked for a suggestion about things that could be included in the 4th volume. If I may suggest or kindly ask that when you decide on how much time to dedicate to what needs to be changed and to how it should be changed, please pay attention to the how part of the question. Because with one document we can annul everything. The other extreme is that you deal with every document separately in a long litigation procedure. So let's find a middle ground, okay? A compromise. Thank you. Well, today is no time or place to discuss it, maybe behind the scenes. Yeah, it's for the volume, for the book, yes. Let me now read out a comment from the internet. I want to read it to give justice to our online participants, to give them the floor. It's a commentary from a well-known and distinguished person, Stanisław Zabłocki, the judge, now a retired judge of the Supreme Court in Poland. You've done an excellent job. This is all to you, so I can just read it out, okay? Without taking the credit to myself. So this is to the authors of the publication. You've done an excellent job. Yes, you have to write the deeds, write the words, as the poet put it, but you should also make sure to document this struggle for rule of law in our jurisprudence. I hope we will enjoy the safe haven of free, independent, and impartial courts at the end of the journey. Beautiful words. Thank you very much. Now, is the microphone working? Yes. Now, there's a point on the agenda which is, it was supposed to be done earlier, but now is the time. We would like to officially present, well, I'm the least positioned to do that, but sir, we would like to present to you, yes, as you know, the book that we have worked on, it is dedicated to Professor Bodnar. Adam Bodnar, as a thank you for his priceless contribution as an ombudsman and the Ombudsman Office, their contribution to the struggle for rule of law in Poland. Let me read the dedication. The authors dedicate this volume to Adam Bodnar, professor and ombudsman in 2015, 2021, to recognize his effort trying to preserve the rule of law in Poland. And the praise for Professor Bodnar is 1/3 of that big book, which is all the documents that the Ombudsman's Office prepared for the litigations in the Court of Justice and the Court of Human Rights. So, Sir Adam, Professor, thank you for everything you have done so far, and we hope you will not leave us. We hope you will continue the good work well ahead into the future. We have put our signatures there, all the editors, the authors have signed that book, the autographs, and also the CEO of the publishing house. So we are very, very grateful to Professor Bodnar.
Ladies and gentlemen, let me just say a few words. It won't be 1 minute that others were recommended. Okay, I'm really moved full of emotions, and I wanted to thank you very much for this honor. I haven't really expected when both the editors called me and Professor Botch told me about this initiative. I was really surprised. Just a few comments, 2 comments. First of all, I've always said when I started my work as the ombudsman, during my work and then at the end, that this is the function. You are like steering the boat into a certain direction. You're steering the tanker with 300 people on board, most of them lawyers, and it's up to those who steer the boat how the boat will sail, whether that will be faster or slower, but this is teamwork. So I look at this award or this distinction as really the appreciation for this teamwork, because most of the letters, the opinions presented, it wasn't my work. I only gave my signature and confirmed, yes, that's the direction we're taking. So I also tried wherever I could, maybe inspire, maybe promote, explain, be it at the European level and also in contacts with other member states of the European Union or in the media, to explain why we're doing all this, what's the reason for that. So let me now talk about a few people who are engaged in this teamwork related to the rule of law. First of all, Professor Grzelak, Director Mirosław Wróblewski, Marcin Malecko as well. He's been here with us. I think he's still with us here. Dr. Mrowicki also gave some additions from the point of view of criminal law. Cezary Węgliński, he had to left earlier, but he was here with us today. And also Dr. Paweł Filipek, who also wrote one of the chapters, Professor Maciej Taborowski, obviously Stanisław Trociuk, and maybe more and more people. Dr. Hanna Machińska was here at the beginning of this event, who has provided so much support for us in the area of international relations. So this is teamwork, and if it weren't for these opinions, these positions, often developed during the nights, late nights. I remember Mr. Wróblewski writing an application, a political one, to the Constitutional Court. We had only 20 hours to provide our position, but we've managed to do that. So, and he was really very involved together with his team. So all that was a lot of work, huge work, that I wanted to thank all of you for and to emphasize why it was so important. And now let me add one more thing, which may not be public knowledge. The fact that in this volume there are amicus curiae briefs included that the Ombudsman was actually presenting in front of the European Court. That was a unique thing on the European scale. Amicus curiae briefs, that was something that did happen before, but again, not in so many cases. So building this relationship of trust, especially as the court invited representatives of the Ombudsman to the hearings, that was very important. Maybe and another important thing was the strategy of joining procedures that were going on before the European Court of Justice. So finding those cases where a question was referred for preliminary ruling and be a partner to the party so that our office could also provide arguments. I think that was also very important, and in many cases led to this and not other ruling. Not all the member states were so willing to support the position of Polish courts or the European Commission. This institutional voice from Poland saying, yes, that's the way in which the rulings should go, that is very important. And I'd like to thank you very much for documenting all this. And referring to what Professor Wyrzykowski said, let me just say that Professor Wiktor Osiatyński would have been really proud of all of you. Okay, so just last element thanks to Professor Barcz, Director Marek Prawda, over to you. Professor Barcz might know what's in stock for him because he just boasted being on the lifetime scholarship from our insurance board. So I wanted to congratulate him on that. But the reason why we're here with all, including Marzena, my successor, Eliza as well, people from the representation of the Euro Commission, we are here because we see here in this publication the crowning of the many, many years of our cooperation when you were our partner, when we were implementing a number of important projects together, and I wanted to thank you for that. People here, previous speakers said about writing down, recording all that was done, all that was said, and I'm not talking here about some responsibility or accountability. It's also important for us so that we know and can defend ourselves in future against such situations, and I'm sure those volumes will be helpful in that. I also think that it is very important for us to remember that that was the time of very difficult challenges, experiences, both political, legal, and ethical challenges. And Janek Barcz was all over the place. He was there dealing with all those challenges. And that's something that we wanted to thank you for. So I won't just say thank you, but I just hope that volume 4 will be the last volume of this publication. Okay, and now we invite you for a snack. Thank you very much for refreshments.